In a ruling that could have far-reaching consequences, a federal judge has ruled against Google in a major antitrust case.
This is Dr. David Shine, and welcome to Business Law 101.
In October 2020, the U.S. Department of Justice and a coalition of state attorneys general brought the case against Google. The allegations were that it engaged in monopolistic practices in the operation of its famous search engine and the sale of advertising tied to it. Specifically, there are allegations tied to its dominance on Android devices. For business law, the law here is Section 2 of the famed Sherman Anti-trust Act from 1890. Many of us learned about this initially in our U.S. history books. Fascinating that a law from 134 years ago could be used against a technology company. Section 1 of the act would be an attempt to create a monopoly. The best example of that would be the famed Rockefeller Standard Oil case from the early 20th century. Section 2 addresses monopolistic behavior. Obviously, there are many different web browsers and a choice of search engines. The issue is the way Google uses its early market dominance to control and maintain its lofty position. The allegations of anti-competitive practices were that Google set up exclusive agreements with browser developers, mobile device manufacturers, and wireless carriers. That would have been okay, but the catch was that these agreements stipulated that the partners would not pre-install other search engines. So most Android devices only came loaded with Google, for instance. In return, these companies made a lot of money from Google. Noted was that in 2021, Google paid an amazing $26 billion in revenue share to these partners based on advertising revenue generated from these devices. Folks, I had no idea the magnitude that we're talking about. On top of this, the plaintiffs claimed that Google could charge super competitive prices for the general search text ads, thereby earning monopolistic profits. Google's response said it was being hammered for having the best search engine. The case is reminiscent of the antitrust browser case against Microsoft in 2001, where it allegedly froze out Netscape and Java in favor of the Internet Explorer. It's one. Microsoft lost that case, but clearly won over time as Netscape and Java went away, and IE now fancier version is pretty dominant. I'm sure the decision of the DC court will be appealed. I think this could be a tough one for Google to overcome. It'll be interesting to see what happens. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.